Greeting and hello everyone. Today we are going to discuss on the case review. Our case discussion for today is R versus Sims. Today we are going to look into fact of the case, judgment of the court, legal analysis, and legal opinion from what we get based on this case. Facts of the case. The appellant was charged on an indictment containing 10 counts, 3 of which alleged buggery with 3 men, 3, as an alternative, gross indecency with the same men, 1 gross indecency with a 4th man, and the remaining 3 indecent assaults on 3 boys. An application for separate trials in respect of each separate man or boy involved was refused insofar as the charges against the 4 men were concerned and they were tried together. The appellant was found guilty of buggery with the 3 men, but acquitted of gross indecency with the 4th man. The main point involved on appeal was whether the judge ought to have ordered separate trials in respect of each man. The counts were properly included in one indictment by virtue of the Indictments Art 1915. However, virtue to Section 5 of the Act confers a discretion on the trial judge to order a separate trial on any count or counts, a discretion with which the Court of Appeal will not interfere unless justice has not been done. It was contended that justice had not been done in this case, because, on the trial on the counts in respect of one man, evidence in respect of the other men was not admissible, and the appellant had, therefore, been improperly prejudiced by the joint trial. Judgment of the court. Court held the mere fact that evidence was admissible on one count and inadmissible on another was not, by itself, a ground for separate trials, because often the matter could be made clear in the summing up without prejudice to the accused. The general principle was that evidence was admissible if it was logically probative, logically relevant to the issue whether the accused had committed the act charged. The exception to that principle, that evidence that the accused had a bad reputation of a bad disposition was not admissible unless the accused himself gave evidence of good character or otherwise under the Criminal Evidence Act, 1898 did not extend further than the interests of justice demanded. Evidence was not to be excluded merely because it tended to show the accused to be of bad disposition, but only if it showed nothing more. Evidence of specific acts or circumstances connecting the accused with specific features of the crime was admissible even though it tended to show him to be of bad disposition. Analysis of the case. In this case, the court reviews in detail the principles underlying the rule that a judge may order separate trial of different counts charged in the same indictment. The general proposition which provides a starting point is that all evidence which is logically probative is admissible unless it is excluded, and separate trials should in respect of another, without connecting him with the crime. Evidence which shows bad disposition alone is inadmissible, but where it shows something more, it is admissible. In the case reported, upon those grounds, it is held that there was no duty to order separate trials of counts relating to sodomy with different men, since the repetition shown by such evidence constituted a specific feature connecting the accused with the crime. The question, therefore, is whether the evidence was admissible. General principle that evidence is admissible if it is logically probative, that is, if it is logically relevant to the issue whether the prisoner has committed the act charged. Exceptions to this rule as evidence that the accused has a bad reputation or has a bad disposition is not admissible unless he himself opens the door. The reason for excluding evidence of bad character was to be policy and humanity. Evidence of bad character was just as relevant as evidence of good character, but the unfair prejudice created by it was so great that more injustice would be done by admitting it than by excluding. There are many cases where evidence of specific acts or circumstances connecting the accused with specific features of the crime has been held admissible, even though it also tends to show him to be of bad disposition. The most familiar example is when there is an issue whether the act of the accused was designed or accidental or done with guilty knowledge, in which case evidence is admissible of a series of similar acts by the accused on other occasions, because a series of acts with the self-same characteristics is unlikely to be produced by accident or inadvertence. Opinion of the case. On this account, in regard to this crime, we think that the repetition of the acts is itself a specific feature connecting the accused with the crime, and that evidence of this kind is admissible to show the nature of the act done by the accused. Even there is probative force, one person might telling truth while the others not unless they conspiracy together. However, evidence suggested that, whilst it would no doubt be in the interests of the prisoner that each case should be considered separately without the evidence on the others, we think that the interests of justice require that on each case the evidence on the others should be considered, and that even apart from the defense raised by him, the evidence would be admissible. If we are right in thinking that the evidence was admissible, it is plain that the accused would not be prejudiced or embarrassed by reason of all the counts being tried together, and there was no reason for the judge to direct the jury that, in considering whether a particular charge was proved, they were to shut out other charges from their minds. With that, thank you.